I'm going to advise those in the public gallery that they are welcome to use mobile devices as long as they are in airplane mode and that all devices are muted. It is not permissible to take photographs or record any part of the meeting. So in terms of apologies, we have one apology from John Blair, and attending via Zoom we should have Anya Murphy, I see Aoife Finnegan on there, and Daniel McCrossan. So members, I would remind you of your responsibility to declare any interests in any of the items under discussion today. Do any members have any interest to declare in relation to today's business? Declan?
Yes, I'm the owner and executive of a small farm.
Thank you. Anyone else? Okay, thank you. So agenda item 3 in Chairperson's business. Item number 1, we have previously agreed to pursue a joint concurrent meeting with the Committee for Infrastructure and to take evidence on 2 bodies that fall within that committee's remit, NI Water regarding Lough Neagh and also from the Planning Statutory Consultee Forum on Planning Issues. The Senate has been provisionally booked for Monday the 20th of April at 10 a.m. for that meeting. So our members agreed to proceed, and the ERA committee team will be organising that meeting and I'm going to chair it. Members are content? Yep. Okay. 20th of April for your diaries, guys. So members, you will recall that the Committee for Finance has requested that we reply to them by the end of February regarding the draft multi-year budget. However, we have not yet been able to organise an evidence session with the ERA finance officials, as they advised the clerk that they are still working through the draft budget with the Minister. Members agreed that we write to the Committee for Finance stating that at this point there is no committee position on the draft budget. Yep, thank you members. Item number 3, members, I refer you to page 6 of the pack to correspondence dated the 18th of February from an individual regarding their formal complaint to the Information Commissioner's Office in relation to a delay in response to a request for information to NIEA regarding its regulation of combustible waste storage at 3 regen waste sites. The individual states that there has been a continued failure of NIEA to carry out its statutory duties under the Environmental Information Regulations 2004 and is requesting that we reply to them as to whether this matter falls within our respective oversight remit. So members, as you know, we do not deal in individual cases, and the individual seems to have a live case ongoing with the ICO. We have previously considered correspondence regarding complaints of odours and waste management at various sites and have raised the issues directly with NIEA and considered their responses in previous meetings. You will also recall on the 18th of September we had a closed session with RAISE to discuss the issues. We then wrote to NIEA regarding further information regarding its odour guidance and considered its most recent response on the matter at our meeting on the 12th of February. So members, have you any comments? Or are you content to note, or do you wish to reply to advise the individual that it is not within our remit to deal in individual cases, but we have been considering the wider issues regarding waste and odours with the NIEA and that it remains on our work programme? It's very possible that the individual may write, again, once the ICO has completed its work in that regard anyway. Members content that we do that? So, content, so there's a couple of options there. So, will we reply to the? I think we will reply to the individual, stating what we've just read into the record in terms of that we don't deal with individual issues, but it is a wider issue that we are aware of, and also refer to the fact that there is an ongoing case with the ICO. If that's okay, Clark. Anything else to add, members? Okay, thank you, members. Okay, agenda item 4 is the minutes of the meeting for the 19th of February. I refer to the draft minutes from our meeting, which are at page 35 of your pack. Have you any comments? Or are you content with the minutes as drafted? And if so, I will sign them prior to them being published on the website. Okay, members, thank you. Agenda item 5, matters arising. Okay, a number of things I'm going to bring to your attention. Number 1, I refer you to page 51 of the pack to a response dated the 9th of February from the Department regarding the interrelation between the statutory rules relating to the rollout of the Sustainable Agriculture Programme, otherwise known as SAP. You will recall on the 29th of January that we considered the diagrams provided by the Department outlining the legislative landscape for the SAP and the flowchart illustrating how the various requirements, conditions and penalties are applied to the FSP, otherwise known as Farm Sustainability Payment. And we requested that the Department share the information with farmers via the DAERA website. In reply, the Department states it will publish the flowchart in due course. However, it is of the opinion that the legislative landscape diagram is of limited use to farmers. Members, just going to invite any comments you might have. I would propose that we write back to DAERA and suggest that they at least provide a link to the legislative landscape diagram from the flowchart so that those who do wish to know more detail on the relevant legislation can indeed access it. Members content with that approach? Okay, thank you. Okay, item number 2, refer you to page 55 of the pack to a response from the department dated the 19th of February regarding the previous committee's concerns in its 2020 LCM and that committee report on the Environment Bill. Members will recall that this committee's scrutiny on the EPPS began in April 2024 and on the 5th of February we agreed to support the draft EPPS. The department states that the current version of the NI EPPS addressed the majority of issues raised by the previous committee and also includes recommendations from the OEP for a stronger account of the statutory due regard duty and also addresses cross-border environmental issues and obligations under the Windsor framework. Have you any comments or are you content to note, members? Members content to note, thank you. Members, I refer you to page 60 of the pack to a response dated the 18th of February from the Minister regarding the Farm Sustainability Payment Entitlement Scheme in reply to matters raised at our meeting on the 5th of February. In relation to the historic years exercise, the Minister states that most farm businesses affected by the exercise are producing grass silage as their sole enterprise. A small number are impacted as they have started livestock or cereal farming after 2021 and therefore will not be eligible in 2026 and no longer have entitlements, but have the option of purchasing or leasing entitlements in 2027 provided that they continue to farm. In relation to the effect of additional eligible land because of the new land eligibility rules leading to an increase in entitlement prices, the Minister states that while extra eligible land may influence price, the Department does not set them. Furthermore, there has always been more eligible land than entitlements, about 1 million hectares compared with roughly 940,000 entitlements activated in each year. In relation to the impact on young farmers following the end of the regional reserve and the Young Farmers Payment Scheme, the Minister states that although 2025 was the final year for applications to the Young Farmers Payment Scheme, successful applicants will receive their top-up payments for 5 years. The Minister also points out that the Farming for Generations scheme, planned for launch in November following the conclusion of the pilot scheme in March, is designed to take a strategic and holistic approach to generational renewal. The Minister concludes that he intends to continue the rollout of the FSP scheme in line with the provisions contained within the Farm Sustainability Transitional Provision Regulations Northern Ireland 2025 and the Farm Sustainability Payment Scheme Eligibility etc. Regulations Northern Ireland 2025 and move forward at pace to develop and implement the Farming for the Generations scheme. So members, have you any comments on that at this stage?
Chair, yes, but perhaps some of the comments might come after the briefing or in the course of the briefing here with the EFU and the
so, yes. Yeah, absolutely. Thank you. Okay, members, item number 4 then, I refer you to page 65 of the pack to the response dated the 23rd of February from the Minister for the Economy regarding support for the ABP Food Group. The Minister states that following ABP's announcement, Invest NI immediately engaged with senior management at the company to explore the best possible outcome for staff concerned and efforts are continuing at present. Have you any comments or are you content to note? Content to note, we'll keep it watching brief there. Okay, item number 5, I refer you to page 3 of the table papers to correspondence from the Minister dated the 24th of February regarding the Isle of Man's Government's newly implemented work visa requirements. Members will recall this was raised as a matter of some urgency at our meeting on the 12th of February by Michelle. The Minister shares our concern regarding the potentially serious implications for the Northern Ireland fishing sector, which he is aware is heavily reliant on skilled non-UK crew. The Minister also states that no advance notification of the changes was received and has requested an urgent meeting with ministers responsible for fisheries and immigration on the Isle of Man to discuss the rationale for the changes and seek solutions to avoid any disproportionate impacts on our local fishing industry. Members, have you any comments in regard to that response? Content to note?
Content to note it's at this stage, but I think there is an urgency in relation to this. So.
100%. Yeah, it's very disappointing to note, although it's no surprise that the Minister didn't get any heads up from officials in the Isle of Man too.
Chair, we have also written to the Isle of Man.
And no response yet?
Not yet.
Okay.
No response.
Okay, agenda item 6 then is the oral evidence session from Ulster Farmers Union and Young Farmers Clubs of Ulster on the farm sustainability payment entitlements. Members, as you will recall, on the 5th of February, we considered correspondence from an individual highlighting his concern about the effect on his farm business at the introduction of the new FSP regulations, the failure to meet historic years' requirements and the subsequent impact on his entitlements. We then agreed that there was a wider policy issue to consider and to hear from the UFU and young farmers to hear firsthand of the issues that they are facing. So, members, I now welcome the following representatives to the meeting, and I'm going to invite them to brief the committee. We have Mr. James McLucage, Technical and Communications Manager at UFU, Mr. Harry Chambers, he is YCFU Era Committee Chair, and Mrs. Roberta Simmons, Membership Development Manager at YFCU. Thank you so much for attending today, and if you'd like to brief the committee and then possibly take some questions at the end of that. Thank you.
Well, thank you very much for the invite here today, and on behalf of myself and Harry, we're delighted to be here just to put forward our case. I suppose in Young Farmers we're very concerned about the absence of the Young Farmer payment within the agricultural support structures, and as has been touched on, without this there won't be as much generational renewal as what we would like within the industry. We would like to see something established going forward, and I suppose with this then carries on the succession as well. So we'd like to see clear policy measures that encourage generational renewal and provide confidence for young farmers to invest and build viable businesses. Within the Young Farmers, we represent over 3,000 members, and I suppose the majority of them would either be full-time farmers or part-time farmers, so there is that interest in the industry, and we need to ensure that there is that support there for the future to keep them coming forward.
Morning everybody. James McLucage, Policy Comms Director, Ulster Farmers Union. Look, thanks for the opportunity for the UFU to come here today. Look, young farmers, the whole young farmers issue, it's succession, etc. After the last year, what we've seen in terms of the inheritance tax debate of what was going on, succession's key. It's the life and blood of this Northern Ireland agri-food industry. I mean, we punch well above our weight here as a Northern Ireland agri-food industry, and if we're going to sustain that, we need to get youth and we need to get young blood coming through. If you take it, the average age of farmers in Northern Ireland sitting around 58, 59, we do have an issue, and we need to start having, we need to come up with solutions, etc., to get through to that issue. In terms of this whole young farmer payment and regional reserve debate, like, it's an issue we've been having with the department and discussions that we've been having as a UFU over past, I would say, really since 2023, summer of 2023, when DAERA suddenly stopped, I would say, the land mobility programme back then, and I suppose it's a discussion that we've been having with DAERA since then. Obviously DAERA, we've got the new farm sustainability payment, and obviously there was a transition scheme. We're through the new farm sustainability payment. We get that. There's a farming for the generations element part of that, but we did have concerns as an organisation with the pilot programme, and a case of, without sounding crude, it's a kind of a state of, well, we told you so. We raised the concerns at this time that we didn't think that the pilot was really the right thing, or was going to tick the right boxes. And I suppose you can see how the pilot went and the results, that we were almost right. But look, let's not look past, let's look forward. Let's try and get something up and running, something which is meaningful. But I think we need to get some sort of short-term gap in there to plug that until we get a good fit-for-purpose young farmer scheme going forward. So look, that's all I have to say now. I'm happy to take questions.
No problem. Just more on a personal note there, that I'm a young farmer myself, and I work for two more elderly farmers, and both of them have two sons each, and neither of the farmers' sons have any interest in taking on farms because they don't see a viable income and a future in it, and it's sad to see in my eyes, personally.
Yeah, 100%. And as James pointed out, the average age of farmers and that, and what is the incentive for young farmers coming through. Okay, thank you very much. Are you content then we take a few questions and stuff? There's plenty of interest in this matter. Okay, I have a few then for you. So, would someone like to maybe offer out some assessment of the impact that the closure of the regional reserve and the removal of the YFP applications after 2025 has had on your ability or that of other young farmers to enter or progress in the farming sector?
Or you want, I mean, I suppose a bit early to say, but the way I look at it is what was around about £2 million was the budget went towards that young farmer payment last year, and I would look at that. That's £2 million going forward, which isn't going to young farmers. We haven't got a scheme there, and I suppose what we want to see as an organisation for any future young farmer payment is actually getting money into young farmers' hands. Not doing schemes, etc., but actually getting. Yes, you can do schemes to get part of that money if it's actually going to develop you as a person. We need to get away from this process of you needed to show you had a 51% share of a business instantly to be able to get that. There's a lot you could be doing before then, and that could be the final actual outcome. But do something to actually get, crudely as this mean, card hold cash, to the actual farmer. So at the minute it's hard to tell, but the way I look at that was £2 million was part of that budget, which was going to young farmers. That's not, as it stands at the minute, that money's not going to young farmers going forward as of 2026.
So it occurs to me that the picture that's forming, there's like a pincer movement that's working against young farmers here. One is the fact that there are no new entitlements, so therefore if you were outside of farming, for instance, so you've made the case for family farming and young people coming through and not seeing the ability to sustain themselves and possibly a family on the family farm, but secondly the door seems to be closed on new entrants as well. Do you see any viable solution? Because I agree with you, James, is that for young farmers it isn't about those training up. For me, it's not about the project needs to look beyond training opportunities and upskilling, because a lot of that is there. The only way that this kind of can work is to drive prosperity, I imagine, and that fiscal levers on farms, and that seems to be under pressure from some quarters in regard to descaling farms instead of upscaling them, and then obviously the planning restrictions that are kind of it's one of those. It's not meant to hurt young farmers, but in it's probably hurting young farmers.
Yeah.
In a greater sense, would that be fair?
Yeah, if any young farmer, these guys can come in after, but for any farm to develop going forward, if you continue to stand still, you're going stagnant. In fact, you're going backwards. You need to continuously modernise, bring in new ideas, more efficiency. A lot of that will require changes to buildings or new buildings. Well, currently at the minute, that's not going to happen. We've got that other, as you mentioned, there's got that. We have to do something with planning as well for young people, and that's another debate and a completely separate argument for a young farmer payment. But we're a complete halt here in a minute, and the industry really is stagnant and dead if we don't get movement there on the whole planning front.
I might have asked you a slightly more controversial question, and one that's probably harder to achieve an answer to, is that given the average age of farmers is older, how do we ensure, how do we work out that there is space? Because we have a finite land mass. There is a top level of what we can produce as well because of that land mass. Is that a blockage? Do you see that that it's harder for farmers when they get older to step off? And is that tied to the viability of the business and that type of stuff?
Well, I suppose from our side, before there was the pilot scheme, the Farming for the Generations, we had the land mobility scheme up and running between ourselves, which was funded by industry as well and was with the Ulster Farmers Union. And we did have a lot of people that was interested in that. Older farmers were contacting the service to get in touch with younger people to bring them on board and get. It also helped them, the younger people, get their foot on that, that farming industry ladder, and get them into the industry as well. But I suppose even from an educational side, all our agricultural colleges, the likes of Caffrey and that, the courses are still sitting full, as well well as Queen's. To the best of our knowledge and belief, the courses are oversubscribed, or they're fully subscribed. So the question is then, what do those young people do whenever they finish their course? Where is the farm for them to go home to, or where is the incentive that will bring them home to carry on that, that tradition, the farming tradition here in Northern Ireland, and to carry on our own local produce and that as well.
Is there enough work being done? Because I agree, I've met lots of young people who are increasingly interested in farming, and I agree, but the pathways, the pathways are there in terms of the education and our colleges and stuff, but actually when you get to the point of, is there enough work being done in diversification? Maybe in the space of horticulture, for instance, and opportunities, is DAERA putting enough effort into new areas and opportunities for young farmers to maybe have a broader swathe of a business model?
I suppose that's why there's the horticulture pilot was part of the future, or part of the sustainable agriculture programme. It is there for young farmers, and I do believe, I've had meetings with DAERA, the whole Lochary campus, they're actually looking at almost redeveloping that and looking at that horticulture line to see if there's new crops or new plants, etc., that we can grow here in NI that we could try and explore. But that almost takes time. I think there's a joined up thinking here could be done as well, where you've got economy, tourism, agriculture there's a model in Scotland that we probably could be following there, and we're the whole food journey and where your food's from, food provenance, buying local, part of the whole tourism. But again, that's requiring everybody, sort of departments chatting to each other, and we can get that, because I think Scotland are a wee bit of an envy on what they're actually doing there in terms of that local provenance, where they've got food tourism, agri-food tourism is a little economy on its own. And I think, well, why can't we? We've as good a story to tell here as they have in Scotland.
Probably better. Should be better.
Yes,
because it's Northern Ireland.
Yeah.
But last one, and if you can make this as brief as possible, because there's plenty of interest and plenty of questions for you. If you were to give me 3 pillars in terms of what specific forms of support you think the department could offer out fairly quickly in regard to financial assistance, training, advice, whatever that is, and then when designing future support, what might that look like?
I can go first if you guys want to come in.
Just encouraging generational reunion, really, and just that farmers will pass down to younger farmers, but younger farmers are going to have to be encouraged, to pass it down to them. Target for young farmers there, sort of, that young farmers for retirement, or enabling younger entrants for access to land, really, and business moderation, really. By encouraging structured succession, the scheme supported investment planning, innovation and farm improvements.
Yeah, and that awareness as young people come through, because it is much more technical to be a farmer than it has ever been in that side. So yeah, okay, well, thank you. I'm going to not hog all the time as much as I would like to, but I'm going to bring in Declan and then Michelle.
Yeah.
Yeah.
Thanks very much. I'm glad that you're up here on this particular issue. Because I just was checking back my notes from last year. This was raised with us originally, from my notes anyway, at the end of January last year, and certainly I know that I and other members of the committee shared the concern about the closure of the regional reserve, and it's something that myself and ours have been banging on about ever since. And if my memory serves me correctly, whenever this was brought back to us as a statutory rule, it was rolled in with the entire single farm payment regime, and had we have prayed against that there to stop that, then the entire regime would have collapsed, which would have had devastating consequences all around. So I just felt that was I wasn't content with how DAERA handled that, put it like that. But this has had an impact, and I've been contacted by a lot of farmers ever since. There's an email that I received from a young woman. She works on 2 dairy farms. Her alarm's set at 3 o'clock in the morning. I finished milking after that there. Then she says, I was delighted to secure some land and start farming on a very small scale on my own right. And then she said that she was nothing in this world would be happier than my own farm. Hence my disappointment that change that you're made, ostracising people like myself for being alright, and I feel further targeted. There's young people like me that will carry the torch of rural communities long into the future. So that there are, and that's the sort of person there. She's got an agricultural degree. She has had the opportunity of land of her own now, and now there is no new entitlements available to her. And that, to me, that will cripple the industry going forward, and it's not encouraging young people. It's actually putting young people off because they don't have that opportunity to get their own entitlements in their own right. So I'm glad that you have come up on this particular issue to raise it, because it's something that has been. I actually got a phone call yesterday about from another farmer as well. So it's, you know, do you believe there's an argument to perhaps extend the regional reserve for until there's another scheme in place that does actually support farmers, extend the young farmers scheme? Because I appreciate, you know, help and advice and mentoring for generation renewal is very important, but I think that in real terms it need to also be incentivised as well. So what would you think is the best solution going forward? I know you touched on Robbie's question.
The quickest way and easiest way for this year is to try and get something in for legislation to roll over what was last year into 2026, and then get a new scheme for 2027. Look, there are early discussions we have fed in as Ulster Farmers Union with thoughts, ideas of what that new farming for the generation. But I'm aware that all have there's a co-design process. There's industry stakeholders all have their views. It all has to go through scrutiny. It has to legislation. It all takes time, and realistically, when will that likely? It probably will be the tail end of 2026 or start of 2027. We'll have it. Plus, it probably is cleaner if it starts from the 1st of January or is available for 2027. So, as I said, like, roll it over and have some sort of fiscal financial incentive for a young person to be able to get them started. Without that, they need money to be able to get started to buy entitlements, etc., or to get their business started.
And just a second point there, you did mention the land mobility scheme. That's a scheme, I believe, it wasn't John McAllister, it wasn't John headed up the land mobility scheme. I did hear a lot of good reports about that scheme. So is that something you'd like to see continued supported in the future as well?
You guys might be conflicted here on what you're saying because you ran it, but I'll come in and say it as like, well, I'll declare an interest. I sat in the steering group of the land mobility scheme whenever it was in place, but the land mobility scheme got together, I think 17,000 acres signed up in agreements, 125 deals. I would call that a success. Yeah. What I did like about the land mobility scheme too, it was part funded by DAERA and part funded by industry. So industry were behind it. Industry, so the dairy processors, beef processors, NFU Mutual Charitable Trust were all part paying that. So they had, what could you say, skin in the game, were helping promote it, realised, you know, a dairy processor might have a older farmer who's near retirement. They want to continue that milk supply, and that was one of the deals. We got a young farmer partnered in, a young person who had no access to land, come in, joined with that farmer, and they actually had they continued that farming enterprise going. That's the type of thing that it went. But that scheme was ended with a month's notice. We were told by the Department of Agriculture we would probably have a new land mobility scheme within 3 months. It took somewhere around 15 to 16 months. It was lumped in with the Farming for the Generations pilot as the farming and partnerships. And I think the whole rebrand didn't work because the land mobility scheme was a known brand. I think ideally what you want to go forward is land mobility scheme is something which stands on its own. It stays as the name land mobility. You put it out to tender again. I would say again, you half fund where industry come in behind because you've got an intent by industry, and then the department fund the other half. And you hope the best organisation which is suited for it, hopefully applies for it, gets the tender and leads that forward, because I think really, in my personal view, is one organisation really is suited to lead that. But again, that's puts the people in an awkward position because they're sitting here.
Well, I suppose I should declare an interest as well, because I was president at the time whenever the Land Mobility Scheme was set up, and I did work quite closely with Michelle and others at that stage. But I mean, it is quite worrying. No later than Tuesday, I took a phone call actually to our Young Farmers Clubs of Ulster headquarters. It was a man in his 60s, he was 62 actually, from the South Down area, and he had a son that was in Greenmount and was worrying about no payment for this guy coming home, and what was he going to do? Would he be better going out in to look for another job in another industry? So I think that's all very worrying as well, that they may be looking elsewhere to take their skills and their expertise, and the farming's being left behind.
And just the last point then is that I just want, I've said this several times, many times in here, I do think it's desperate that a new entrant, in most cases a young farmer, just cannot go and apply for entitlements on their own right. And just maybe an opinion going forward, we have a situation now where we have a pot of entitlements there, and entitlements will die off. There's situations where entitlements which won't be activated over a course of a couple of years will for many reasons will extinguish, right? Take into the fact as well that there's thousands of new hectares coming into the equation under the new land eligibility, which will put more pressure on that finite pot. So going forward then, do you think that there's then actually a danger in terms of the value, the price of those entitlements? Because young people are now, new entrants are going to be forced to go and lease entitlements of other farmers. So is there a danger now that the value of those entitlements, or the cost to lease them, is going to increase to a point where it's just not affordable?
I'll come in that one. Where us as a UFU have actually put forward the suggestion that it's not related to entitlements, it's an actual payment. So don't relate it to entitlements. It's a payment to the young farmer.
Yes.
You give them a payment, regardless of size, what they're farming. You give them that payment, and it's fair and equal, and everyone gets the same payment for a young farmer. So there's not this competition and scrambling for entitlements. I've been through a lot of our committee structures, and that's maybe a radical new way of thinking. It's maybe the fairest way going forward. It gets back to that. It's fiscal. It's money getting into the young farmers, pocket going forward.
Thank you for your indulgence, Chair.
Thank you. Can I just ask one question before I bring Michelle in? Is there anything that you can see from the land mobility exercise coming through in the Farming for Generations? Has there been anything in regard to your negotiations with DAERA?
Part of the one of the key pillars is the farming with partnerships, which I suppose is the new, what they would say, rebranded land mobility programme. But as I said there earlier, I think part of the problem with that was it recognised that this was the new land mobility programme. Land mobility was a name, it was well known. Yeah. Why change the name? Go back to you build up a brand and then you suddenly end it and you have to rebrand the whole exercise. It just didn't work.
It doesn't make sense when there's no trust, when there's very little trust about it at the moment, to be honest. Yeah, it's a minor. Michelle, thank you.
Well, thank you, Chair, and thank you all for coming up today. And I find this hugely frustrating that we're having this conversation, and I suppose it reflects back even to what Declan has said, and the fact that feels a bit like Groundhog Day, in that we were having these conversations last January. And I remember specifically the contributions that were made. I also remember asking for yourselves to come to this committee for us to talk about what the potential impacts were likely to be. And there were interventions from outside of this room. I was on the cusp of actually voting against the SR. And the fact that it was tied was obviously something which was done, I feel, deliberately. But I suppose really the killer move in some ways was the fact that we did get a response then from the ASPG, which obviously Wesley was the chair of, which said APSG supports the draft affirmative SR. APSG stakeholders supported that both the Young Farmers Payment and the Regional Reserve should continue until 2025. The continuation of these schemes beyond 2025 was not an option. Again, hugely disappointed that that was stopped at that particular time, and there was no sort of flexibility after that. And then goes on to talk about the development of the proposed introduction of a farming for the generation scheme as the policy instrument to support generational renewal going forward is ongoing, and APSG welcome the opportunity to engage in this conversation as well as all the other areas of DAERA's new programme of farm support. So there's a couple of things coming out of that, I suppose, that concern me, and I suppose it really is this whole issue around whenever you're talking about the farming for the generation scheme, and the fact that we got correspondence from the Minister, which you may have caught the tail end of whenever you were coming in, where he seems to be moving on with this project. Obviously in discussion, I'm guessing, I suppose, with yourselves and other stakeholders, but as you said, it is a co-design piece. There are stakeholders who are outside farming who are also involved in that, which creates itself a problem, and I suppose that takes us to the issue around perhaps these types of groups, and whether or not they are, supportive in the same way as you will be. Can you maybe talk to me about the current pilot project, what the feelings are of it, where there are likely to be changes, and if any, or if you're feeling that the department is being responsive to what you're asking for? And you've also said that you are looking for something for 2026, and I'm mindful of the time, and time is marching on in order for something to happen for 2026. How receptive have officials been to those requests?
I'll go by a sort of a timeline. We raised concerns as an organisation with the pilot, from what we seen the draft pilot in September 2024, and we said this is not what's needed. This is not going to work. Again, everything was ran down to the wire last February, where it was, if this legislation doesn't get through, then the wider piece, we don't get legislation done for the full scheme. People don't get money, and you're almost being accused then as almost the UFU's at fault for people not going to get. You'd no alternative but say, right, we've got to get this through. I can tell you now, if from APSG meetings, I would say the DAERA are sick of hearing from James McCluggage on the issue of the pilot. I kept raising concerns about the pilot, so the pilot ran obviously March to March. We've asked for as an organisation, we asked for an update on how the pilot was going. Numbers were not great, but we were told that numbers were not great. The reason why numbers were not great was because of the nervousness was out there. People didn't know what was happening with inheritance tax, so people didn't know whether or not they were going to hand over. There was a real nervousness out there, and people didn't know what to do, and they were going to see if there was going to be sea change within Labour government. Roll that on, and I still kept raising, not so sure whether that's true or not, or maybe it's just the fact that the actual scheme and the figure, and I'm not going to go in there to the figures, but the figures are out in the public domain. Figures were not great for any of the four pilots. In fact, the farming with partnerships was very poor compared to what the Landability project done. Obviously, Keir Starmer done what he done on the 23rd of December in terms of inheritance tax. We didn't see a groundswell of uptake for that pilot in January and the start of February. Which would make me say, my personal opinion is, well, it is what we said from the very, very start, that the pilot was not the answer from the very, very start. So yes, we have been raising continuously throughout the year. There's a farming for the generations subgroup has been set up to look at a future scheme, which the UFU sits on with the young farmers, NIAPA, the banks, and the Agricultural Lawyers Association are all sitting at. They meet quarterly, and we had a meeting. We had a meeting there recently, a month ago, and effectively UFU, we had ideas, and we floated the ideas that everybody has, but that then needs to go to the full APSG. I think that meeting's taking place now in 2 or 3 weeks to go through for the department, etc. Now, I'm confident that we'll probably get, I think they've maybe realised, probably should have listened to you at the time, but again, we'll not look back, we'll look forward. But it's going to take time. As you all know, it takes time to design that, get it through legislation. There might be some people object, or within other stakeholders might not see. So I think we need a bit of blue sky thinking with this as well, and where it doesn't need to be related to entitlements. It's something different. You actually just give the young farmer a financial incentive for being a young farmer, for taking it on, and at the end of that, you maybe have to go over to, but it's not where you need to. Completely different. I think that mindset of at the start, remember you had to go 51%. That was the very first thing you had to do. Well, why not flip that around? You at the end of it all, at the end of the scheme, have a 5-year scheme, and that's the very last thing that you do, where you seriously consider, do I want to be the 51% shareholder in a business, to work that up? Because one thing is United, and one thing I would notice from doing so many UFU meetings over the past year, succession is an issue. The inheritance tax brought it to the fore. Succession is an issue. The number of farm businesses who don't have anything in place is quite frankly scary. Okay, so what happened last year, and that hasn't gone away. There's still some farmers. So it's still a topical issue with what happened in inheritance tax. So now's the time to actually put a proper scheme in place till we get it, because we really do need to reduce the average age.
But my concern, though, is whenever I read the Minister's response to the committee, is he's suggesting subject to all necessary approvals, which obviously take time, so you work back. He's hoping that to have the scheme launching in November, and the fact that you're sitting here not displaying a huge amount of confidence as to what that contains, that concerns me. And also the fact that there's no mention of anything in the shorter term, which is obviously what you're looking for in order to bridge that gap for 2026. So, I was keen for you to come today to speak to us, because I think there is an urgency in relation to this, because as we move forward, time lapses and we move into a further year, perhaps with no support, which is critically needed within the industry. So I'm really pleased that you're here today, and at least we're getting something on the record with regards to that the committee then can follow up on, so thank you.
Thank you so much. Well, that's good, Michelle, actually. And nice to be back into the correspondence with the APSG in regard to where we are, but it's really important to get these.
Frustrating.
Yeah. Thomas.
Thank you, and again thank you for coming along today. We have got correspondence from different people within the area with regards to the concerns they have for the young people staying on the farms going forward because of this. So if you don't see a rollover into 2026 to bridge the gap that you're talking about until some future scheme comes into place, what damage do you see that doing to the young farmers coming into the farming industry?
I'll start. I look at this in terms of mood music. What kind of perception is that for Northern Ireland Agriculture PLC if you don't have something there in place for young people? The life and soul, it's the foundation of what we're built on. We need, as I said before, we need young people continuously coming through to keep the industry evolving. So, it's not particularly good optics not to have anything. If we're really serious about generation renewal and keeping and about young people in the industry, you need to have some sort of scheme in place. And look, you have the scheme in place. It's a business decision whether somebody goes for it or doesn't go for it. But you need a scheme there for them to apply or not. It's a business decision if you want to go for it or not. So
I suppose without clear support mechanisms for young people will then enter the industry as such, and that obviously then threatens rural economic resilience, innovation, sustainable land management and future food production, as we've touched on before. So I think that we definitely need that generational renewal and something then to entice them to go forward.
I suppose without some sort of scheme coming towards the age of the farmer, as James said, at 58, it's going to go up instead of come down. And you probably all don't want to go any higher than what it is, because you want younger people coming into the industry to try and push forward and make the industry more economically viable.
Okay, thank you, and thank you, Chair.
Thanks, Tom. And Gareth.
Yeah, no, it does. It's very interesting. I'm not on the committee that long, but I do have some knowledge of it, and my members of my family are involved in working on farms and that. I'm just wondering, in terms of that piece where you've maybe, as Harry has said here, where you're working for a couple other farmers whose own family just don't have the interest in doing that. And I suppose sort of the resurgence I see, among young people in terms of trying to get work on farms, I see that as a real interest piece for them. And as you have said, the colleges are full, the courses are full does that hide a wider issue in terms of young people wanting to get into farming, but how do they get into it? And then for the people that they are working for, I think in terms of them relying on young people to do a lot of the jobs that you're doing, that family members aren't willing to do or wanting to do because they're pursuing other interests. They're not, just because you grow up on a farm doesn't necessarily dictate that you're going to want to work on a farm for the rest of your life. And I think we're seeing that more and more, where people are getting into other industries and they're maybe not as committed to remaining on a farm as that would have been the case maybe 20, 30 years ago. So does that hide a wider issue for the future? And does it, in my mind, I think it does bring it into a far greater significance, paving a way for people to remain on a farm. Otherwise our food security is going to take a hammer, and we're going to be relying on, imports more than we should be, and that's not a good thing. We've seen that over COVID, how important Northern Ireland's industry was in supporting the whole of the UK practically through that whole pandemic, and having our food security. But I suppose from Harry's perspective, how do you, and I know you can't say a whole lot because it's a live session, but in terms of what those farmers feel, how are they feeling about they're paying you to do a lot of the work? What's the ultimate end game of that in your view?
Well, they're trying to rely on me to do the work that they're not able to do themselves. And, it's maybe becoming a danger for them because they're trying to work with cattle and do all these jobs that maybe 2-3 people are needed for, and they're not, they're trying to do things themselves. It's becoming a danger nearly for them. It's the farm safety aspect you can't bring into it, I suppose, too, Nick. Yeah, it's because the people aren't there to do the work.
I'll come in there. I think there's a piece of work which could be done on game with the education programme. I think there's a wider piece which you could do in terms of an apprenticeship programme within agriculture.
Yeah.
And I think that there's huge potential here. It gives where a young person maybe no access to land but can go into an apprenticeship, an agricultural apprenticeship programme, where they almost get paid to be in that apprenticeship programme. They're fully skilled, fully trained up, and then you partner them almost with a farmer, older farmer.
And I think that's going to be, I think it's inevitably going to happen because you have, as you've said, older farmers, so they're getting less able to do a lot of the tasks themselves. Yeah. They haven't that input from their family for obvious reasons. They're pursuing other interests, and jobs, I think, in that line of things are going to become even more relied upon. But it also has another reflection on where the industry goes then after that.
I suppose on the back of that, Gareth, succession planning requires stability and multi-year commitment, and it's not that not 1 year pilot scheme. It does need something 5-6 years at least to sort of embed that for the person that's coming on board.
Gareth? Declan, you'd indicated you would like to come in.
Just maybe a suggestion that the Minister's correspondence, he made reference there about supporting that this was a legacy scheme that was to support the transition to a replacement scheme. We don't have a replacement scheme, So what I'd be suggesting, if the committee was minded, is to ask the department to review that regulation. And rolled over.
I would support that.
Yep. Yeah. And do that. Yep. You content? Anything else you want to add before we wrap up? But that you're aware of what Declan has suggested, and we're content to carry that one out. Is there any other?
Another thing, it's sort of the blue sky thinking, which the UFU have raised too, is you take the average age of the farmers 58, 59, and everyone thought, historic European schemes, young farmers referred to 40. Well, does the new 40 need to be 45? And why I say that again, blue sky thinking, if it does anything to try any future scheme as the new 45, if we can start to reduce that 58 age down, well, that's positive change. And do we need to start looking at future schemes? And I know one thing I would also to sort of put on the record, I know the department would be quite keen that any new young farmer coming in must be level 3 or going forward, whereas at Union we're very much level 2 minimum requirement, because you know, there's some good young farmers coming through there, coming into the industry, who maybe don't have that level 2 in agriculture, but maybe went and done a degree in accountancy or went a degree in engineering, but just at that love of farming and want to come home to farm. Is you saying that that person's not skilled? They've come up with a degree from Queen's University Belfast. Are you trying to say then that they're not skilled enough to be in the to be a farmer? Don't really say that. That's where the whole thing the whole thing needs revitalised and fresh thinking, new fresh ideas and thinking.
Okay, that's very good. I like that. Like the transferable skills is a very relevant thing to add in. Okay, thank you very much. Happy enough. It was really good. Really appreciate you coming up at this time, and it's as Michelle pointed out, it's a critical, crucial time that we are informed as this thing develops legs. Literally, thank you very much for your time.
Thank you for the opportunity, folks.
Okay, thank you.
Thank you.
Michelle? Just sort of to end, I think as a follow-up, it might be useful to have rural support to come to speak to the committee, as well as officials who are involved in the development of the next project, so at least then we can have some input into that and to see where they are in the development process.
Yeah, do we have rural support? I think would they
Maybe on our list.
I think they're on the list, but
They're on
what
our
we'll do is off the back of this today, we'll get the words in terms of including that, and then see if the date needs to be either if we have a date or we'll bring it forward. Okay, and we've obviously Declan's. You happy enough, Clerk, with the wording of that?
Yes.
Okay, thank you very much. Okay,
Thank you.
see you soon. Thank you. Okay, members, are you content then that we move on to agenda item 7? Okay, members. Agenda item 7 is the Dilapidation Bill and Committee Deliberations. So, members, today we are continuing our deliberations on the Dilapidation Bill, and I welcome again officials from the department. It will be Simon Webb and Mark Allison. Today they will answer questions and discuss issues as we go along, and we'll also have our bill official, Ozone Baker, and Glenda Doherty, our senior assistant clerk, who is predominantly working on this bill. Through all that anyway. Through this one, but not this one.
Yes, not the stuff in that.
No, I wouldn't bad, like. Not that bad. Okay, members. So you've been provided with papers in the pack for this item. The deliberations table updated after last week's meeting starts at page 8 of table papers. The bill as introduced is at page 70. The explanatory financial memorandums at page 98. The statutory guidance and defective premises draft guidance starts at page 110. The convention rights memo starts at page 160. The LLP delegated powers legal advice starts at 179. Committee stage issues raised by clause starts at page 193. And the Hansard reports related to the bill of the 25th of September 2025, the 5th of February 2026 and the 12th of February 2026 are pages 454 to 471. I'm not going to list the remaining papers in the pack as they have been in our pack each week so far to date and can be found between pages 232 and 453. So members, with your agreement, we're going to move to deliberations. Okay. Okay, members. Clauses 1 to 15 were discussed at our meetings on the 5th and 12th and 19th of February and have been included here for reference in case the committee wishes to return to them. Just for note, the convention rights are noted in green text under the relevant clauses. So members, the round table discussions between their officials and NILGA, BCNI representatives took place on Tuesday, and Glenda and Ozone were in attendance. An informal note of this meeting has been prepared by Glenda and included within the table papers starting on page 26. A further meeting has been scheduled for Monday the 2nd of March. So members, I propose that we discuss with officials the outcome of both these meetings at next week's committee meeting and get on with the remaining clauses in the meantime. And I'm going to propose that we start at clause 16. Members content with that approach? Okay, members, you find clause 16 at page 19. So Simon and Mark, if you wouldn't mind, and welcome back, if you would please give us an overview. We're starting all right. I need to turn my pages too to make sure I'm on the right. Okay. There we go. Yep. So if you want to give us an overview of clauses 16 to 20, and members, those are the miscellaneous functions of district council. So members, in relation to clause 16, just to give you a heads up, we have heard that concerns that this clause is weaker than the existing Article 72 of the Pollution Control Order, as it would limit their ability to obtain ownership information from agents or solicitors. I'm going to advise members that in terms of rights engaged, the committee should consider whether any interference with the Article 8 rights of the person from whom the information is sought is justified and a proportionate means of achieving a legitimate aim. The aim in this case being to obtain information about owners occupiers of the relevant property or land of which this is subject of the notice. Okay, thank you. If you want to give us a brief on, we're taking clause 16 first of all.
Clause 16, thank you, Chair. Clause 16, the notice requires the recipient to provide information about the ownership of the property and of any other person who may have an interest in the property. Failure to comply with that notice is an offence punishable in the Magistrates' Court with a fine of up to £2,500. It would also be an offence to make a false or misleading statement in relation to the notice, and that will be punishable in the Magistrates' Court with a fine of up to £5,000. And it's also, you can go to the Crown Court and be fined on indictment, or the prison sentence is there too. Clause 16 is a current power in various pieces of legislation. That note that mention has been made of Article 72 of the 1978 order. The clause itself was based on Section 330 of the Town and Country Planning Act 1990, which we actually discussed at our meeting on Tuesday. Some of the local government officials were querying, was the Section 330 power included, and we were able to confirm that it was under Clause 16. But we can certainly look at the Article 72 power. It's more of a broad power that would enable the Council to require information from basically anyone.
Okay. I just have one question, and you referenced obviously Article 72, which is the bit that I read in terms of the concerns about it being a weaker power. You're saying it was a broader power, but is it redefining the purpose of Clause 16, and then that is out with the wider powers under Article 72, or do you think it?
It's basically the same power as Section 330 of the 1990 Act.
Okay.
It's more tied to people with interest in the land, but we've tried to broaden it out. But I mean, we can look at the wording of 72 and, you know, amend. It can be amended. You know, we're not going to die in a ditch over it.
Okay. Members, any further queries or questions on?
Just wondering, in terms of, circumstances, could have one in my own constituency where, a bank has some type of interest in it, but there's a real difficulty in actually finding out who ultimately owns it, and land registry isn't coming up trumps and that type of thing. What does the council do in that circumstance, or how prescriptive is that clause in terms of ultimately finding out that information?
Yes, well, certainly a bank as a financial institution would potentially be a party on which the council could serve a notice. And if the bank has an interest in the property, then equally they can be approached to provide information. Yeah.
And, somebody who occupies the land or directly or indirectly receives rent for it, but we're talking usually a building that's not worth habiting in any shape or form, you know what I mean? So I'd say that's less likely a possibility in terms of finding out that information, you know what I mean?
Yes, there may be absolutely cases where it will be harder, depending on the nature of the property, to identify a specific owner. But if there is a third party with a potential financial interest, if there's a mortgage on the property or that sort of thing, then yes, they would fall within the definition of an interested person.
We touched on this previously in regard to slightly more complex arrangements around trustees of buildings and property, where you have multiple names and some that cannot be found. This may be an issue for the courts rather than distinctly the legislation, but in terms of the offences and penalties, are there any irregularities, or is it common practice that it's already covered in terms of, so if you have 12 names of trustees, 8 of them can be found, 4 possibly deceased or can't be found. Is there a test in law in terms of the fairness of offences and penalties, do you know?
I don't know, Chair, but certainly we'll check that out for
could you-
next time.
yes.
Yeah.
23 there.
Yeah, what
When we talk about partnerships in clause 23, 6, the individual partners, I'm not sure if that's what you're getting at.
Could you just explain that a wee bit more to me? So, in terms of clause 23, you think might just if it does assuage me that
If an offence is committed by the partnership or proved to have been committed with the consent or connivance of one of the partners, that the partner as well as the partnership is guilty. So, you know, any individual partner could be.
I'm thinking of the rights that you know when this butts up against the rights of so if people in good faith, obviously, for charitable purposes or for organisations will enter into trustee arrangements, and at that point, then it's an equal share of the offence and the fines and so on. But just through death or unintended consequences, that type of thing, these things maybe sometimes aren't kept updated. So it's not a deliberate; it's an unintended consequence of people falling foul. So in terms of the offence and so just maybe if that was even to be considered in terms of it might be covered in clause 23, but I'm not sure it is specifically because the courts will obviously determine the scale of the offence and so on. So, but a wee bit of clarity just in and around that because these things could and should be tidied up if we can. Is that okay?
Yep.
Any members, any other questions or queries in regard to clause 16? No. Okay, members, then we're going to move on to clause 17, and this is in relation to consultations with the planning department. We've heard that Ulster architectural heritage have concerns that various existing relevant council powers under Planning Act Northern Ireland 2011 are likely to be duplicated or in some cases weakened by this clause. Clause 17.1, it was recommended that this clause be amended to include clear emergency consultation procedures for listed or heritage sites. Clause 17.4, consideration should be given to whether the definition of heritage site in the bill should be widened to ensure that the significance of other non-listed historic buildings and built heritage is not overlooked, and that over 70% of respondents to the informal survey were of the view that protecting historic or heritage buildings could sometimes limit the council's ability to order demolition. So we're just going to invite the witnesses maybe to speak to clause 17.
Okay. Clause 17 provides that before issuing any notice relating to a heritage site, that council officials must consult the relevant officials in the council who exercise functions in relation to that type of heritage site, or if it's a historic monument, it would be the Historic Environment Division of DFC. Turning to the bit about the duplication, the use of powers in the bill to tackle dilapidation at an early stage, in the case of heritage sites, would obviously preclude the need on down the line for the use of an urgent works notice in the Planning Act. So we don't see a duplication, it's more of a complementary power.
Okay. Just wondered, if you could give me a clear definition of 17.4, which says that the department may by regulation amend this section so as to change the definition of heritage sites for the time being contained in subsection 2. What does that actually mean then?
It basically means if on down the line something changes in that field, that we can amend the definition to include it as being a heritage site.
For specific cases? Is this for specific case or is this in terms of the...
There's a general change to, you know, the heritage.
Conditions of what pertains to being a heritage
Yeah.
site or building, okay. Okay, thank you very much. Do you feel that the clauses would benefit from an amendment to include clear emergency consultation procedures for listed or heritage sites?
Certainly, as currently worded, the bill does say that before issuing a notice in relation to the heritage site, the council must consult with the planning department, etc. We are mindful of the fact that there isn't a notice per se with emergency action, so we would be happy to elaborate on that perhaps in the guidance itself to make that clear, that there should be emergency consultation, provided circumstances and timing permits.
Yeah, I'm sure members will be aware of there are issues within our planning departments within local council at the moment anyway in terms of just normal business. I'm just wondering, and I know that this is an ask from some people, but I'm just wondering about, we have to also balance up the real world availability of qualified staff to perform a function.
Yep.
I mean, if we don't, when we're changing, so that's something we'll probably keep a very live eye to. Members, are there any other questions or queries in regard to clause 17? Okay. Okay, members, thank you very much. We're going to move now to clause 18, power of entry. And we have heard, and it was highlighted, that the Planning Act provides that where consent is refused, entry can be obtained from a lay magistrate. So the rights engaged here are Article 8. The committee should consider whether any interference with these rights is likely to be occasioned by the clause and whether the mechanism set out in the clause represent a proportionate means of achieving a legitimate aim, the various aims being the inspection or examination of land or the carrying out of works. Okay, and are there any comments that you'd like to make in regard to clause 18?
Give an overview of the clause, yeah. Okay, under existing legislative provisions, council officials can exercise a range of powers of entry and inspection. Clause 18 provides for occasions where a council official may enter land in the council's district for the purposes of the bill. There are various notice periods provided for in the clause. They're pretty general notice periods, similar to Section 98 of the Local Government Act 1972. There's no notice for emergency, 24 hours for examination only, 6 days for any other purpose. And there's also access by force, which is currently in Article 72 of the Waste Order 1997. The clause also covers compensation and inserts a offence of obstructing an authorised officer, which carries the penalty of £2,500 fine on summary conviction.
Yeah, it's so it is it's a substantive power, power of entry. Obviously, it does obviously cross over and it has to be dealt with as sensitively as possible. But it's something that's very much needed. Is this? I know we're getting the table of the carryover legislation. Is there anything new or novel in this clause?
No,
and has there been anything raised in the past? Has there been any test on this in terms of its efficacy, its adherence with human rights, for instance? Has there been any test cases against this in the past that you're aware of? Or cases, never mind test cases?
Whenever the departmental solicitors were scrutinising the bill, I mean, they were fine with the power of entry. They had no issues with it at all in relation to human rights.
Okay, and in regards to the comment that was made just in regard to where consent is refused, the entry can be obtained from a lay magistrate. Is that extant anyway, or does it need to be on the face of the bill, do you think?
That was a new one to us.
Okay.
I'd never heard of, obviously it's in the Planning Act, but
Yep.
I'd never heard of it before.
Okay. No need for it to appear here, do you think? Or is there any issue, any reason why it wouldn't appear here if it's on the Planning Act? And if the purpose here is to bring as much legislation that touches and crosses over into one bill, would that be reasonable? Do you think? Is it something that we might?
Yeah, it's
because it's an existing power.
Yeah. We could certainly have a look at it. Yeah.
Okay, cool. Thank you. Okay, members, have you any other questions in regard to clause 18? No? Okay, good. So, members, in relation to clause 19, which is around fixed penalty, we've heard concerns that fixed penalty amount was too low to act as an effective deterrent. Suggestions that there needs to be an option in this clause for repeat offenders, and the issue of a second fixed penalty or amend Schedule 1 to proceed to court if non-compliance within a specified time scale after has been paid. Approximately 70% of respondents to the informal survey do not consider the fixed penalty high enough to deter property neglect, and Youth Assembly members felt that the fine should be scaled based on the site owner's resource and status. Members, the rights engaged here are Article 6. Clause 19 may engage Article 6 as the payment of a financial penalty as an alternative to determination of criminal liability by a court. However, fixed penalty schemes are generally considered compatible with Article 6 as they are voluntary alternatives to prosecution. A person issued with a fixed penalty notice can reject the penalty and retain their convention rights of access to court. A couple of little questions for you, if that's okay. What is the Department's view on including an option in this clause to deal with repeat offenders?
Thank you, Chair. So essentially that is already factored into the bill. The £500 fixed penalty discharges liability for conviction, as you were saying, but it isn't in place of carrying out the actual works required in the notice. So there would be an expectation that the works would still be carried out by the property owner who has paid the fixed penalty. If they remain in breach and they've paid the fixed penalty, there will be the option for the council to issue a fresh notice, and with that, again, a fresh fixed penalty each time, should it be the case that the property owner continues to be in breach. We did discuss this issue yesterday, obviously, on Tuesday, with the representatives from Nilglen Building Control. There may be an argument around the size of the fixed penalty, the amount of the fixed penalty, and that's certainly something we're happy to consider.
Nobody's asked about what repeat offender means, and you've picked up one way that repeat offender could be is just someone who doesn't carry out the works and stuff, but the other repeat offender could be someone who owns multiple properties. And right across, I think, most of our towns, a lot of our town centre properties are owned by a small number of people, and a repeat offender could be someone who owns a number of properties and is subject to a number of notices and doesn't comply. Yeah. Is that worth considering? Because you could have multiple instances of loss of amenity, which, when added together in an area, for instance, constitute a significant loss of amenity. And if that multiple property owner, in terms of that repeat, I'm not even sure this would stack up in law because each one would be a breach. But is it something that's maybe worthy of considering?
I think that would probably be quite an administrative burden for the councils to link up each property that maybe has its own individual circumstances, and it may be that one has a dangerous structure notice on it, the other might be a maintenance notice, and it would probably become quite an administrative challenge to tie those up. As currently worded, the bill allows, as I say, the council to issue multiple notices on the same property and different types of notices on the same properties and different properties over time. So I think it's fair to say that a property owner who is in breach can still, be in receipt of significant penalties without necessarily joining up all their individual properties.
Yeah, so the £500 fine, for instance, could apply multiple times on the same property for different offences?
Yes.
Potentially?
Yes, absolutely.
Potentially?
Yeah.
That's it. Well, that's another aspect of it, so thank you for that. Okay, and then the final one from me. Have you any comments on what the committee has heard in evidence regarding the fixed penalty amount being too low to act as an effective deterrent? And this did come up many, many times.
Okay, same question.
Same question. Oh, sorry.
Yeah, no, it's okay, it's okay.
And I'm Aoife.
So yes, and I touched on this when I first mentioned that the amount of the penalty certainly has come up with discussions with Nilga and Co. And firstly, we go back to the point: the fixed penalty in itself is not meant to be the actual deterrent. It's a way of discharging, liability for conviction. It's not a way of, avoiding doing the necessary works. That said, if councils are going to find themselves in a scenario where they have to issue repeat fixed penalties, then the amount becomes relevant. Obviously, say for argument's sake, a larger penalty of £1,000 is probably going to have to be issued fewer times than a £500 penalty before somebody takes action. But certainly it's not something the department's fixed on, and we're certainly open to the possibility of that amount being increased.
Thank you. Declan?
Chair, thank you. Just on the same theme, and you're right, the £500 was highlighted as not necessarily like an incentive. But one of the issues that also did come up during our evidence gathering was the importance to differentiate between a speculative developer and compared to someone who has inherited a property in a dilapidated state and they can't afford to restore it. There's a big difference there. £500 maybe wouldn't be a lot to a big property developer who may be set to make millions out of it or whatever, but someone who, for whatever reason, ends up with this property and it becomes nearly a burden on them more than an opportunity. So is there a means where the legislation can differentiate between those two?
So certainly, I mean, I don't think we necessarily have to legislate explicitly for that scenario, but the current bill provides sufficient flexibility for councils to act on a case-by-case basis and look at the circumstances of each case. So for argument's sake, where somebody has inherited a property and the council understands their individual circumstances, they may prefer to say, well, look, we'll put a charge on this property requiring works to be done in the future, as opposed to you carrying them out now. That's one option that would be open to the council, in which case then there would be no penalty relevant, to the person who has happened to inherit the property. Whereas in the case of the speculative developer, council may say, you've been holding on to this site for quite some time, you haven't been developing it, etc., etc. You've left it in a poor state, and we are going to take action.
Thank you. Thank you, Chair.
Just on that point, and more actually your response to that point, it was an issue again around flexibility from council to council, and I suppose this is a repeated concern for the committee, and the fact that again you could have, with boundaries and so on, that across the road could have a completely different view on an approach. So I suppose it's just raising that point with you again around
Appreciate that
flexibility.
No, absolutely. So I think we're in agreement here with the committee and with councils that there has to be a balance struck between flexibility and attempting to achieve a degree of consistency. And in that regard, we have spoken with, the local government representatives. We'll be considering options as to how that more degree of greater consistency might be achieved.
Again, I suppose I'm not really clear as to whether or not consistency is required on the face of the bill as opposed to in guidance or conversations, because again it becomes open to interpretation.
Yes. At the moment, the department's preference would be certainly for it to be addressed in the guidance, and if it is going to be statutory guidance in that regard. It is, as I say, something that came up on Tuesday in discussions, and that we've said we're happy to work with councils on in the coming weeks. In terms of putting in place the greater clarity that they feel they need.
Could I ask you a wee question then in regard to, in the future, measuring the efficacy of the dilapidation bill? Because whilst the powers are conferred to council to collaborate, cooperate and get the fixes, the department will be the bill owner, I suppose. What does measurement look like in the long term? Maybe to pick up on Michelle's point of how, is there a test that is going to be, that you can point to in guidance, or is there something we need to help develop for the monitoring, reviewing and improving?
Certainly there was an original intention to potentially require councils to carry out surveys of their particular council district and establish how many properties were potentially going to fall under each notice and identify the scale of that problem. But that would have imposed a statutory duty on the councils and would have included obviously a sizable price tag. So at the moment, as currently stands, in terms of reviewing this, it would be subject to the normal post-review procedures to a team in maybe a number of years, 2 to 3 years' time, revisiting the subject and reaching out to councils and establishing how things are going at that point in time.
I think it's a question that's not for you guys, but raised with NILGA in terms of the baseline for the current assessment of dilapidated buildings and impact of amenity on land and whatever. It was for NILGA maybe to see if we're trying to get a baseline, because we don't know what the baseline is. It's really hard to measure improvement.
Certainly one, and it is a bit of an older report now, but we do have the Ulster University report, which attempted to put figures on this and the numbers of properties that would fall within the regime, and put sort of ballpark figures on the amount of remediation costs, etc. So we do have some feel for that by way of that report. But but it's not. It's a desk-based exercise. It's not a specific list of actual properties.
Okay, I mean, technology's moved on a great deal, probably because obviously with the Google, I mean, as you say, desktop exercise, they have some value, but with that the Google Drive-bys now, which is okay. Okay, thank you very much. Any other questions on this, Gareth? Did you want to come in there? Sorry, no. There you go. Okay, moving on. So we're now going to look at clause 20, which is guidance. No issues were raised in the survey, as guidance was not available at that time. However, we have since seen a draft of the guidance, and it's also been shared with the councils for their comment. And I'm sure the council have heard the concerns at the round table with officials on Tuesday, or will at next week's meeting. Can you share, and would you like to share any feedback received from the councils specifically in regard to guidance, given that it wasn't available at the time for us when we went out to the public survey?
Yep, we discussed the guidance, and we clarified with councils that the guidance would be statutory guidance, so it would be available in front of the judge. A lot of their concerns, which we've gone through, we said that could be addressed by amending the guidance, and we were talking about some sort of matrices to put in, try and tie down definitions and when they would act and things like that. So, they're happy that we could work together and get the guidance as tight as we can possibly get it.
Excellent. Okay. Procedurally, then, in terms of future, you can't future-proof it, but it needs to be agile enough. Changes to guidance would be done by draft affirmative. Yeah.
Yes.
Okay.
Have to lay a draft before the assembly.
Okay. Any other questions in regard to that one, members? No. All right. Okay. So, members, I'm going to bring clauses 16 and 20 to a conclusion. Any further information needed from the department, please let me know. And further discussions can and will take place next week's meetings and beyond until we conclude our deliberations. So we're not closing it out. We're just closing it out for today, just to reiterate that point. Members, okay? Yep. Okay, Simon and Mark, we're now going to look at clauses 21 to 23, which are general procedure matters. So, for members, there were no comments made in relation to clauses 21 notices, clause 22 appeals. And would you like to give us a bit of a brief in regard to clause 21, first of all, please?
Yes, clause 21 is a general provision basically providing for issues relating to notices issued by councils, such as the taking effect, variation, withdrawal, etc. We would like to point out that any notices in relation to the urgent works under clause 10 or clause 11 in the defective premises clause, that they may not be varied or withdrawn, as they obviously relate to works requiring relatively rapid remediation, so they will not be subject to variation.
It could just be sort of described as a bit of a common sense approach to notices, in that the varying degrees of danger obviously are reflected here to protect probably unnecessary pressure, but obviously the failure to comply with the notice still has it's up to the council whether that's planning or building control, and then the fine still sits as a deterrent for non-compliance. Anybody, any other queries in regard to Declan?
Yeah, Chair, this came up in the evidence gathering as well, because in different councils you're going to have different local development plans and different emphases, and is there a means whereby we can ensure consistency across councils in relation to this?
Again, we will try to tighten the guidance and make sure, in collaboration with the councils, that they're going to be supplying us with what they currently use to determine these sorts of things. And they mentioned the matrix, Belfast mentioned the matrix that they had. So we can tie all this in and try and ensure that, as far as possible, that all councils are working on singing off the same hymn sheet.
And Gareth?
Yes, just in terms of notices, I know from a council's perspective, if there's an abandoned vehicle or anything like that, there is a visual notice placed on that vehicle, and it's very clear to residents in a built-up area or any passerby that council has clocked this car or vehicle or item, and they've given a period of time in which to be dealt with. Is there any move under this to do something similar? Because a building is very visual, and we're talking about usually built up areas in most incidents in these cases. So is there any potential under that to have some type of visual indicator placed on the building that it is now under notice?
Certainly under the Interpretation Act, serving of a notice can be by affixing it to the building.
Yeah.
So,
Might be the worst thing to do, just that the public know, right?
yeah.
And also for the owner that, I mean, we have scores in the doors for restaurants and everything else, really visual indicators
Yeah.
that, council is and the health perspective from council is taking an interest in all those
Yes,
types
right,
of
absolutely.
buildings. So is there not a case that then if an owner, and it mightn't always be the case, but usually in any circumstances I've dealt with dilapidation, it's been an unwillingness to address dilapidation by an owner. So is this another way to maybe really put a footprint on it that, look, we're on your case here?
Certainly, the council has the ability to affix a notice to the building or something on the building, or
Does that clause allow that to be the case?
well, the Interpretation Act would cover that.
If I could just add as well, on that point, the draft statutory guidance mentions the ripple effect, which is reported for properties in England where maintenance notices have been issued, and there's a tendency then if a property has a maintenance notice served on it, other properties in the area become aware just through word of mouth, through conversation with neighbours, and other properties owners will tend to often take action on their own property before then a notice is even served because they're aware of what's happening in their neighbours.
Enough, Gareth? Yeah. Okay. We'll look at clause 22 then. You don't mind if you have anything to mention in regard to that, or you're going to have some questions?
Clause 22 again is a general appeal clause, providing where if the notice is served, when the notice is served, if someone appeals, the period stops, the clock stops, but that will not be the case for emergency work. There will be no stopping of that.
Okay. And is this new or novel? Is this a carryover from current practice?
This is basically a general clause. Obviously, we've had to put in the bits about the emergency work.
Yeah, that doesn't apply. The appeal doesn't apply to that one. Okay, yeah, makes sense. Okay. In relation to clause 23, before I ask you the previous, it was suggested that a daily fine should be introduced for repeat offenders, as in the case for Article 66 of Pollution Control in Local Government, Northern Ireland Order 1978. Have you anything to give us in regard to then Article 23, considering just what I've basically spoken in as one of the concerns that was raised?
Yes, we are certainly aware of the power under Article 66, but we have contacted the Northern Ireland Courts Tribunal Service on 2 occasions now to verify that they do not administer daily fines. So although that power exists, it is not currently something that the court service uses or administers.
It hasn't been repealed, it's just something that hasn't been used in practice?
Yep, indeed.
There was a bit of interest, obviously, in terms of that repeat offender, and we tried to. It wasn't looking a definition for it, but obviously, is it something that you think that wouldn't be useful to? Because if it's on the statute book, then
Yep, it's potentially useful if there was to be the administration on the part of the court service, but we're very much being advised that won't be the case.
yeah, we can't compel courts. Obviously, it can go to court, and we can't.
So we would obviously rely then as to the situation I was referring to earlier, where if there are continued breaches of a notice, fresh notices can be served and fixed penalties and fines associated with each new notice.
Okay, members, any further queries in regard to that one at this stage? We can return to it. Members content? Okay. Thank you. Okay, we have now looked at clauses 20 to 23. Going to bring them to conclusion for today's business. Any further information needed from the department, we can request that. You can let me know. And further discussion can take place at our next meeting and subsequent meetings. So, going to now turn to clauses 24 to 25. We'll read this in before you give us a bit of an overview. In relation to clause 24, the meaning of interested persons. Clause 24.2 should include receivers for the company that formerly had an interest in or ownership of the land. And that was really, I think, the only thing that was offered in regard to clause 24 in particular. Would you like to give us an overview, please?
Yes, clause 24 is fairly self-explanatory. We wanted to ensure that the definition of interested person was as broad as possible. And the comment about the receivers, we would consider that the current definition with someone who has a charge in the land or another financial interest in it would be considered sufficient on the basis, that a receiver acts in the best interests of the creditors who have a financial interest in the land.
I see my friends, the trustees, get to be mentioned in this one specifically. So they do. Okay, I don't have any further questions in this one, in this regard. Members, does anybody else have a question? This one? Oh well, sorry, there's one. In terms of the piece that I read in, should it include receivers for the company that formerly had an interest in or ownership of the land?
Yes, I was just...
Yeah. That's
the
point,
yes.
Sorry.
Yeah.
Okay. Brilliant. Okay, thank you. Okay, we're going to move on to clause 25 then, which is other definitions. So it was suggested that the phrase building includes any other structure is too broad, as could be applied, for instance, to crown buildings, lampposts, railway gates, which already are controlled under other legislation. And another point was that DFI planning highlight that from a planning perspective there is an overlap with the definition of building which is provided at clause 25 in this bill and it's provided at section 250 of the 2011 Planning Act, which on the surface appears mutually inclusive. So do you think there is an overlap? And is it concerning? And have you considered it? And if there's any other further overview that you'd like to do in regard to clause 25, please do so.
We considered that the phrase building includes any other structure, we didn't consider that it was too broad because crown buildings we disapplied anyway. The definition is very similar to the one in the Building Act, 1984, and as well as the Planning Act. The meanings are very similar, but it's probably more convenient to have the definition laid out in the act that it's talking about, rather than having a person going, the building refers to section whatever of the Planning Act, and having to go and look up.
I agree.
Another piece of legislation.
Agree. And is it in any way? Is it in any way in terms of the definition? Is it substantively different from any other definition in another piece of legislation? No. No. Well, that's good. Any other questions in regard to that clause, members? Clause 25? Okay, I'm going to bring today's discussions on clauses 24 to 25 to a conclusion. Any further information needed from the department, please let us know, and further discussion can take place at next week's meeting or subsequent meetings. Okay, going to turn to clauses 26 to 28. Before you give me an overview, I'm just going to read in. Members, the following general comments were made in relation to clauses 26 to 28. Solis and Nilga highlight that there are elements of the legislation, albeit imperfect, that it is proposed to repeal and that are absent from this new bill. These elements have been proven to work over many years. It's essential that these omissions are amended in a revised bill prior to the repeal of the existing suite of legislation, and that clear guidance is required to ensure consistent application of repeals and regulation. And we've spoke to you before in regard to the volume of legislation that maybe need to be repealed, which probably triggered that piece that I was saying, is this new, is this novel, and does this have any impact on the repeal? So can you maybe even give us an overview of the gaps that have been identified in that process for repeal, revocation and confidence that the legislation will take effect and there'll be no gap? Yes, I'm not sure if you have sight of the table yet. I think it maybe only went out Monday or Tuesday of this week from the private office. We have laid out the repeals and set out where they are in the new legislation. We went over this again on Tuesday with Nilga.
we specifically asked them, tell us what power you're talking about, and we can, but we didn't really, it was more of a general, you're getting rid of this and we need it sort of thing.
Mm-hmm.
But I mean, we're confident the minute that anything being repealed is being carried forward.
So I think it's been repealed, is being modernised, tidied up, and that'll be reflected, but there'll be no gaps in terms of the timeline. You would imagine, in terms of the process for repealing the legislation, then.
The repeals will come in whenever the bill comes in.
It basically falls.
Yes.
As part of the bill structure. Okay.
We're shooting forward here, but the commencement clause.
Yes.
We had initially made it the appointed day procedure. That was to do with what Simon was referring to earlier, the survey that the councils we had thought were originally going to carry out, but that has now been removed. So it may be that we just commence the whole bill, on the day after royal assent.
Okay, and just for confirmation, we don't have that updated that table yet. But hopefully we'll have it maybe for next week. I think you said it was issued at the start of the week.
Should Monday or Tuesday.
Chair, sorry, it was literally just arrived. Committee in behind.
Get you on your phone there, Simon. So it was sent at just for the record for Hans. It was sent at 20 to 12. No problem. Thank you very much. I appreciate that. Okay. Members, any other questions in regard to that clauses 26, 28? Content? Okay, thank you, members. So before we move to the overview of clauses 29 to 31, which covers the general interpretation, commencement and short title, as Mark referred to there, there were no comments made in relation to clauses 29 to 31. Just let me peel through it on my table papers here. Okay. Yep, okay, members, are there any... Do you want to give us an overview, sorry, before we move to questions?
Of 29 to 31? Yeah, at 29, the general interpretation clause, it contains the meaning of department and statutory provision. Fairly straightforward clause. As I already mentioned, the commencement clause, we may come back to that and enable the Act to come into operation on the day after royal assent, just so as we're not having to make commencement orders for no reason really. And the short title is self-explanatory.
On the commencement piece, and maybe just going back one wee step, I know you're engaged obviously with NILGA, and we've had witnesses in the legislation takes effect. Is there any work that you're doing with the local councils in the broader sense through the different stakeholders, including elected reps, for the awareness piece of the new bill, so that I know it's not necessarily, well, it'll be the council's responsibility, but you guys obviously have a role to play in this, that there is an overt awareness, and is there any programme that is put together to create that awareness and work through how the bill will be applied in real life?
Yeah, I know whenever it received executive approval, the Minister was very keen that press releases were sent out, to alert the public that this was on the way and whenever it was introduced again. So I would imagine that as we go through the different stages that there will be some sort of publicity campaign or whatever form it takes before the bill comes in.
We will be meeting with the Minister in early March, so those issues will probably come up then in that discussion.
Yeah, I think at the very early outset, certainly something that I'd raised in terms of the committee, and I think the committee were interested, is the communications piece. So it's about not over or underselling what the bill will do, and also ensuring that people had the information and were aware of the new provisions, if there are any new provisions, and even the repeal for the professionals that will be applying the thing. So that's grand. Probably just keeping aware. Would like to keep aware of how that's rolling out. So, have any of the other members got any queries or questions in regard to clauses 29 to 31? No. Okay, we're going to bring those ones to a conclusion for today's business. Any further information needed from the department, please alert us. Further discussions can take place at next week's meeting or in further sessions. Okay, Simon and Mark.
Chair, can I alert Daniel sending apologies? He's been unable to log in.
Okay. Okay, so Dan, just for members to note that Dan McCrossan has had significant difficulties getting logged in today for today's meeting. Just he has alerted us. Okay. Okay, now we're going to look at a brief overview of Schedule 1, which is the fixed penalties. So before you give us a bit of an overview, I'm just going to read in for the members' concerns. The fixed penalties do not act as a deterrent and that they're too lenient. Also, ability to reduce these by 25% if paid within 14 days is an insult to those impacted by the dilapidated premises. So it's a statement. Council's raised issues that Section 10 of the Schedule 1 states that the receipts for fixed penalties could, by amendment of regulation, be accrued by other persons, including the Department. So unless the Department provide financial support to assist with the enforcement of this proposed bill, then councils cannot see any justifiable reason for the Department being able to amend regulation to accrue fixed penalty receipts, and they recommend that this provision be omitted from the bill. So if you want to address those two issues, please.
So just to be clear there, Chair, the first issue being around the amount of the penalty. Yeah, and as previously mentioned, the Department is open to the potential that the penalty could be set at a higher level, but reminds councils that it is not in itself meant to be a deterrent in terms of avoiding doing the work. It's not in place of carrying out works. On the issue of where the receipts from the fixed penalties accrue, the clause in the bill is a standard clause. It is not the Department's intention that we plan to regulate to take receipt of those. It would be very much the Department's position that those receipts should go to councils to assist with the costs of the administering the scheme.
Okay, we'll probably pick that up again probably with the local councils, I imagine, just as to see how tied and fixed they are to that provision being there. I think they're reasonably robust in trying to see if they could have it omitted from the bill, but we'll work with you on that to see if we can get some comfort or assurance, I suppose, around that. Are members content, or are there any questions in regard to Schedule 1? Okay, members? Finally, Simon and Mark, could you give us an overview then in terms of Schedule 2? And just for members, there were no comments made in relation to Schedule 2.
Well, basically, Schedule 2 sets out the repeals, and we have set out in the table each section of those old acts, what they are, what they do, and where they are replicated in the bill, and if not replicated, why not. There are one or two are obsolete. One talks about removing people to the Belfast workhouse, so I don't think we can keep that one in.
Good old days. Yeah. Okay, members, are there any questions or queries in regard to that? Obviously, we can come back to it. No? Okay, then I'm going to bring both Schedules 1 and 2 to conclusion, and any further information needed from the Department, please alert us through the clerk, and further discussion can take place at next week's meeting. All right.
Chair, probably know at the point where next week's meeting we'll be working with our bill official, maybe in a more closed session to discuss get into the issues in detail and then come back to open session to ask the officials questions. Okay. We're sort of moving on a phase.
Yep.
Since we've been through it all once. Yeah.
Okay, and to close by clause, I imagine, isn't it?
Well, this is in the informal clause by clause, Chair, is the next sort of part.
Okay, so that was a number of useful sessions, so thank you for your attendance, and I'm sure you will be back to walk through the next stage of this. Okay, thank you very much. Okay,
Thanks, everyone.
Okay. Okay, members, suspend. Just going to suspend the meeting for a short comfort break, so if we could all be back at the table for 12 o'clock, please. Thank you. So we're in open session again, and we're now at agenda item 8, which is the SL1, the sheep carcass classification and price reporting regulations for Northern Ireland 2026. So I refer you to the clerk's memo, which starts at page 491, a copy of the SL1 letter from the 15th of January, starting at page 494, and a copy of the SR and explanatory memorandum, which starts at page 502, and the equality screen document, the rural needs impact assessment, and the regulatory impact assessment, which starts at page 529 of your pack. I also refer you to response from the Northern Ireland Meat Exporters Association, NIMEA, starting at page 593. So members, the Department intends to make the SR under the draft affirmative procedure to introduce mandatory sheep carcass classification and price reporting in Northern Ireland. It also makes classification of sheep carcasses aged less than 12 months and price reporting of the same mandatory in Northern Ireland for all slaughterhouses, which slaughter at least 1,000 sheep per week as a rolling annual average. Members, you will recall this was the first SR that we've considered under the new process for dealing with subordinate legislation. So at our meeting on the 22nd of January, we agreed to note the receipt of the SL1 and the proposed SR and consider the policy detail of the SL1 today. We also agreed to conduct a call for views via Citizen Space, to which no responses were received. A separate response has been received from NIMEA, which highlights a number of unintended consequences, potentially, including increased cost and reduced efficiency, hygiene and food safety, and undermining of NI competitiveness. We also invited views from the Northern Land Sheep Task Force, but to date no response has been received. So members, I now welcome the following officials to the meeting and invite them to brief the committee. We have Dr. Samantha Stewart, Head of Food Security, Beef, Sheep and Pig Policy, Mr. Kieran Coughlin, Deputy Principal, Food Security, Beef, Sheep and Pig Policy. Thank you very much for attending today. If you want to brief the committee, please do so.
Morning, Chair and members. Thank you. I'm grateful for the opportunity to brief you today on the statutory rule introducing mandatory sheep carcass classification and price reporting in Northern Ireland. By way of background, both Great Britain and Northern Ireland, it is mandatory to classify beef and pig carcasses in terms of shape and fat and content quality for market prices to be reported to the Department. Arrangements in Northern Ireland relating to the classification and price reporting for sheep carcasses is currently voluntary. Following a UK-wide consultation on the remit of the Grocery Code Adjudicator, a recommendation was made to investigate introducing mandatory sheep carcass classification across the UK in order to improve fairness and transparency. A full public consultation was run from the 8th November 2021 to the 16th of January 2022 to seek views on introducing a mandatory system. There were 3 responses from organisations, 2 in favour of introducing a mandatory system, while the other was opposed. A further targeted consultation ran from the 5th of February 2024 to the 5th of April 2024 to clarify a few areas not covered in the previous consultation, including around authorisation of automated classification. This further consultation had 3 responses from organisations, 2 in favour of the proposals, while the other was opposed. The Department provided the committee with written briefing on the outcome of the second consultation at its meeting on the 20th of February 2025. While consideration was given to the possibility of retaining the existing voluntary system, this was discounted as it would not provide consistency and transparency to all sectors of the industry, which a mandatory system would provide. It would not provide the Department with the necessary enforcement powers to ensure high standards, and it would leave the sheep sector out of step with beef and pig sectors, and Northern Ireland would differ from the rest of the UK. Minister Muir decided to introduce a mandatory option via legislation using domestic powers provided in the Agriculture Act 2020, and this is subject to the draft affirmative resolution. I'll hand over Kieran now to outline the details of the SR.
Thanks. So the main requirements within the SR are that it will apply only to sheep aged less than 12 months in age, only abattoirs slaughtering at least 1,000 sheep per week as a rolling annual average, or those who slaughter fewer than this but choose to classify sheep carcasses will be required to follow the requirements. It's estimated that over 90% of the sheep aged less than 12 months slaughtered in Northern Ireland will be captured by setting this figure at 1,000, but that will also avoid adding additional regulatory and administrative burdens on the smaller abattoirs. Classification may be done by visual means by a person licensed by the Department to do so, or by automated means which have been authorised by the Department. Provisions relating to automated classification methods come into force later than the rest of the regulations. This delay is necessary to collect the robust data sample needed to calibrate automated methods to NI flock and to assess and authorise these. There are currently no automated methods in use in Northern Ireland. Carcasses must be presented for classification using the prescribed standard. Nothing else prior to classification may be removed from the carcass except for veterinary reasons. While the GB administrations are allowing an alternative presentation, this alternative presentation has never been used in Northern Ireland, nor was the idea of introducing it here suggested at consultation. Classification of carcasses will be based on shape, which are conformation classes, each designated by one of the following letters: S, E, U, R, and P, S being the best, P being the worst. and fatness classes designated on a numeric 1 to 5 assessment. The meat industry is familiar with this carcass classification system through the mandatory scheme for beef carcasses, and the abattoirs that already voluntarily classify sheep are already using this system. The carcass must be weighed soon after slaughter to calculate the worm weight. The cold weight is then calculated by subtracting 2% from this worm weight. This aligns with the beef and pig sector process. This differs from the current practice of subtracting a flat 0.5 kilogram from the worm weight, and that may therefore require some software changes for processors. However, it provides for a more accurate cold weight, and it is consistent with the rest of the UK. Regulated slaughterhouses must label and keep records which detail the weight, classification result, and category of each sheep. Records must also document the ear tag number, which allows for the producer to clearly identify the animal, the classification result, and the price paid. Details of each individual classification must be provided to the animal supplier and to the Livestock and Meat Commission. For sheep purchased individually on a deadweight basis, the prices must also be reported to the supplier and LMC. This will allow for market transparency and analysis. The department will have powers to audit and enforce the regulations. Slaughterhouses will receive unannounced visits from DERA inspectors on a risk-based frequency. These inspections will look for potential breaches of the regulations, mainly in regards to carcass dressing, classification and weighing, as well as licenses, record keeping, labelling and reporting. It will also be considered a breach not to comply fully with these inspections. Any breaches can result in the department issuing a warning letter or an enforcement notice. Failure to adhere to these could lead to DERA seeking prosecution at a magistrate's court. The department will also have the right to amend, alter or revoke licenses in cases of poor compliance. The SR allows for appeals against these enforcement proceedings. Back to Samantha.
Thank you. So we consider the changes to be minimal, as much as what the SR requires has already been done voluntarily, and there's been communication and engagement with stakeholders regarding the changes that will be introduced. And the main concern from the processors will be the requirement to comply with severing the tail between the 6th and 7th caudal vertebrae. Whilst the department's position that this is bringing the industry in line with standards in the EU and GB, it is understood that this is a change from current practice where the tail is completely removed. While we would accept a certain bedding-in process for the new requirements, we would not expect there to be significant enforcement proceedings similar to the current situation for the beef and pig schemes. England, Scotland and Wales have already enacted similar legislation, albeit with different thresholds to reflect local industry scales. In the South, classification and reporting remain voluntary, but follow EU standards equivalent to those set out in the statutory rule. Subject to the committee's views and Assembly approval, the rule is tentatively proposed to come into force on the 30th of March 2026, where the slaughterhouses must notify the department and obtain their licences within 28 days. From the 27th of April 2026, mandatory classification and reporting requirements apply to all relevant sheep carcasses. And then, as we touched upon, there's a delay period for the authorisation of automated methods in the 24th of May 2027. So in conclusion, the introduction of mandatory sheep carcass classification price reporting will ensure greater transparency and fairness across the supply chain, provide robust enforcement mechanisms and ensure parity with the rest of the UK. Thank you. I appreciate there was a lot of detail there, so happy to take any questions that the committee may have.
Thank you so much. If you don't mind, I'll start with a bit of a busman's one for me. So I used to be a butcher, so I know it's like dealing with sheep and lamb carcasses. But when they come into the shop, they wouldn't have had tail on them. But a query has been raised by NIMEA where they've stated that the requirements for severing of the tail is not a simple task and will require skilled operators. I think you've alluded to the fact that it will be a slightly different methodology to be employed. They suggest that it creates unnecessary additional costs, as well as having the potential to cause some hygiene concerns from a food safety aspect. Have you a different perspective on that? Or?
Yes, so as I said, with engagement with the processors after the Minister made his decision to implement the legislation, and this was a consistent thing raised with ourselves. So we understand that, yes, it is a change in practice, but the key point of this is that there's standard processes across the UK and Ireland that every carcass is treated the same up to the point of the scale, and that's where the weighing's done and the classification's done, and then anything after that, the carcass can be further butchered for customer specifications, so the tail can come off at that point. As I said, GB, England and Wales are slightly ahead of us in terms of this legislation, so we made inquiries with them in terms of how it was bedding down with them. And similar, they were saying that they were having some pushback in terms of compliance with the specification, but once they made it clear that, this is what's in the legislation, you can do whatever after that, then they've been compliant. I know the other concern is hygiene requirements. So we sought the advice of our veterinary colleagues, and there's no veterinary requirement for full removal of the tail. But this legislation does allow for, if there's visible contamination, for trimming of the tail, which would be in line with the veterinary requirements and this legislation.
Okay. A wee bit, something that's I think quite intriguing is the fact that it's optional if you slaughter less than 1,000 sheep or lamb. Is there any implications then? Because there is a claim that the department claim that the mandatory classification will improve price transparency, fairness in producers. But for those that slaughter less than 1,000, is the reverse then going to happen to them? Are you suggesting then that if they don't comply and apply the same standard, then that they will not see the same price transparency and fairness?
No, I think it was the balance for the throughput was in terms of regulatory burden in those small abattoirs, so that's where the threshold has come from. And it's not a suggestion that by not having it mandatory that there are problems. It's just that now we have the powers that if there are issues that we can correct them. I think.
Yeah, as regards price transparency, because as Matthew said, that 90+% will be captured with the ones above the throughput. With the smaller ones, obviously producers will still see that 90% of data and will be able to compare the price they get from the smaller abattoirs. So there still will be transparency. They just won't need to contribute their data to the prices published.
It does say in the paper that I think the department saying is that the assessment of the implications, whether they're regulatory or financial, are minimal. Most of the costs are probably going to be borne by the department. Is that still the case?
Yes, so I understand they're currently mainly doing this. The big change in the short term is they'll have to spend some time getting their licences. We anticipate to try and do that in one day, so to try and minimise people out of the abattoir and stuff. And then the software changes at the scale to change from half a kilo to the 2% deduction. So.
Okay, and then my final one is the SL1 states that additional inspections for DAERA would cost about £2,000 a year. Discussions are ongoing with England and Scotland and Wales in terms of how automated machines will be authorised across the UK. What is the authorised machine? What is the purpose? What does it do? And where are we at the moment now with regard to the processes mirroring what's happening on the mainland?
So there's currently no machines for sheep in Northern Ireland. I'm not aware of any. It would be a commercial decision for the abattoir if they want to bring one in place. We do understand that there's a number now for the beef, and they're that they're pretty highly regarded in terms of that independence between processor and farmer for the gradings. But the throughput of beef is much higher than sheep. So as I say, it's a commercial decision whether the abattoirs would purchase one. With regards to the automation and the authorisation, we're still working through guidance on that and how that might work, but it was anticipated to be similar to what was done for the beef machines in 2010, 2011.
Thank you.
The requirements for automation are contained in Schedule 2 for the SR, but yes, some of the practical things, how it would actually work, we're still working on that.
Okay, thank you. Thank
you, Chair. I suppose the starting point for me is that what's in the best interest of the farmer, the primary producer. That's the first interest, and we know from looking at the food supply chain that they're the primary producer, but there's an imbalance in the whole supply chain which hasn't been addressed by the grocery code adjudicator. I'm aware that in the north, I think we export in around perhaps 500,000 of sheep south. So we're going to have a mandatory system in the north and a voluntary system in the south. So will that place our farmers here at any sort of a disadvantage?
So the requirements in this SR replicate what's in the EU legislation. So it's the same standards, the same presentation. Whereas in the south it's the voluntary, so staff them are doing the checks. So they're still the same standards, it's just we would have higher standards to check the compliance of the abattoirs. But it's the same presentation of the carcass, so there's no difference between the carcass presentation and the grading. The grading system's still the same as well, so it's the same grades. So the grades in the north and the south are the same.
Just to explain exactly, and the voluntary and the mandatory part. Is this the onus on the processors, or where does the onus be placed on if something becomes mandatory?
So there are EU regulations which basically say you do not have to bring in mandatory sheep carcass classification price reporting, but if you do, this is the standard, and it's that standard to which in the Republic of Ireland they work towards, but it's a voluntary system there, so they have no enforcement powers. But as Smith says, it's basically the same standard. Sorry, did that answer your question? Or?
Yeah.
So in the south, they can, if they come across issues with the presentation, say the length of the tail, they can ask the processors to bring it more in line with what the requirements are, what the standard should be. But there's no obligation for the processor to comply with that.
Yeah. And then we'll see. If it's a more transparent and favourable regime for the sheep farmer, would that create a situation where they might want to, process their sheep in the north?
The difference between mandatory. I think it's fair to say it's going to take a while to see this bedding in terms of the practice, but from what we've seen in England, it's fairly smooth. But I'm not anticipating, because they're the same standards, north and south. It's just that we, the department, have the powers to correct.
And there's no potential of this slowing down the production line effectively.
Slowing down. So one of the requirements of this legislation is that the ear tag would be provided. The UFU had asked for transparency reasons, so the farmer could match up which sheep they were being paid for, because for genetics and breeding type of thing, so they knew what price they were getting. So that read happens on the line, and sometimes that read doesn't happen 100% of the time for the ear tag number. So rather than making it mandatory to take stop the line to take a manual recording of the number, we've worked with the processors to understand what the requirements are from that. So if they have it, they must provide it. So yes, sorry, no, it shouldn't slow down the line, is our understanding.
So if there is an issue with the ear tag number, it's, from what we understand, it's not a very common issue. So sheep generally go through in batches of 10, and the majority of them will read in the scanner. There might be one where the tag's been damaged or something, but even then, because they're in a batch of 10, they should be able to work out, okay, that's the old one, so that must be that ear tag number, so that's not an issue. And there might be the odd time where two are broken in the same batch, and to be honest, we've got a bit of discretion there. Like we don't need to enforce if they're doing their best to read them and the scanner just plays up and they can't match it. We have that level of discretion, so I don't think it will affect the line.
Thank you. Thank you.
Okay. Aoife?
Yeah, thanks. So it states that the farmers are in favour of the regulation and the meat processors are against it. So does that mean that the farmers will get a better or a fairer price if the regulation is implemented?
So all the carcasses will be treated to the same standard. What was happening more so in England than here was that there was excessive trimming of the carcass before it was weighed, and that trimming, those materials were sold for other uses, which resulted in the farmer not getting paid for those. So as now we standardise it so everybody knows what they're getting paid for. So they're all getting paid for the same.
Okay, so just for clarity, farmers are not being asked to pay for implementing it?
No.
Okay, perfect, thank you.
Members, any other further questions? No? Okay, thank you so much for your time. Appreciate it. Okay, members, we have a couple of options at this stage. Have we got any prospective dates for any ambition for the end of this? Okay, probably just ask.
Or what? Yeah.
I'm going to ask the members to invite them here just to list it, because rather than picking questions.
Yeah, well,
Just for the deliberations and that, like that, is that we really have.
This is all sides after, so
You're going to hear me folder.
Members, so we're in this new dispensation, which gives us a little bit more time if we want to hear more, and when we've heard enough, I just would ask you to indicate to me, but I'm going to suggest that in this instance we invite NIMEA to provide an oral evidence session before we make a formal decision on the SR, and what that does is, if NIMEA want to provide evidence, then they can come and provide evidence, and if they don't, then they don't, and that of itself is an indication to us as to where industry would be. Dr. Stewart did mention some communication they'd had with the UFU maybe in this too, and I'm not suggesting we bring UFU. What I'm suggesting is that we did open up the public space there. I mean, there's still a week or two for this to go before the SR is laid, so we'll write out to the NIMEA and contact them to see if they want to come and offer evidence. Michelle?
Can I also suggest that we haven't actually heard formally from NIMEA on any issue during our period within this committee. So while we could ask them to come and specifically talk to this particular SI, it might be useful for them to broaden that out if members were content.
Yeah. Content?
yes, they have been on our list for quite some time, so it would be useful.
Okay. We'll put them forward. We'll see if we can put them forward. Yes.
Chair, I agree with the proposal from NIMEA, but I also there seems to be a difference in opinion between the NIMEA and the producers.
Mm-hmm.
So I think it would be helpful if we could get somebody to speak on behalf of the producers as well.
No problem. Yep. No problem. It's good to this will put it into the sheep into line with the pigs and the cattle, which sounds noble and appropriate, but at the same time need to bottom out in terms of those unintended consequences, and that everybody is aware of what's happening, and that it's coming with as little cost and friction as the department would tell us. Content?
Yep.
Okay, remember, so that's what the next action will be. Clark, are you content that we have?
Chair, sorry, so you mentioned producers, any particular?
Perhaps the UFU, or if there's a perhaps.
So they know about it?
Yeah.
Okay.
Okay. I was content. And there was the sheep task force were contacted, but they didn't. Yeah, we could maybe just reach out to them to final time, possibly just to let them know we've had the session and alert them to that, and give them one final chance, and then we'll have to move on. Members, okay? Thank you very much. Okay, now agenda item 9 is the Ozone Depleting Substance, ODS, and Fluorinated Greenhouse Gases Provisional UK Common Framework. So members, this is the first of 2 common frameworks we're returning to today to determine if we are content that our scrutiny role is complete. The previous ERA committee scrutinised 9 of the 15 common frameworks, for which DERA is the NICS lead. This committee agreed to arrange evidence sessions with officials on the 6 remaining CFs to identify any issues and potential for their scrutiny. We most recently agreed that our scrutiny was complete on the Waste and Resources Framework on the 25th of September and the Air Quality Framework on the 11th of December. Members, you will recall that we first considered this common framework on the 20th of March last year, and we agreed to return to the matter. So I refer you to page 597 of the pact of correspondence from the Department dated the 18th of February, seeking confirmation of the Committee's content and that its scrutiny is now complete, or if any further clarification is required. The briefing paper, which we considered previously at our meeting on the 20th of June of 2025, when we were briefed by officials, starts at page 599. A copy of the Provisional Framework Outline Agreement and Concordat start at page 603, and a copy of the Hansard of the briefing on the 20th of March starts at page 668. So to recap, both F and ODS gases are used in several sectors of NI industry as coolants. These are enclosed in products and equipment and are not usually emitted unless by accidental leakage. If emitted, F-gases can exacerbate climate change and ODS can cause erosion of the Earth's protective ozone layer. The UK ODS and the F-gases Common Framework Outline Agreement and Concordat is already operating provisionally, and the Department has stated that it does not have any concerns about its operation to date. Are members content, or are there any further clarifications from the Department needed on this? Content? Yep. Okay. So we can now say that our scrutiny is now complete, and we know that all these common frameworks will be reviewed once they're finalised. Okay. Thank you, members. Agenda item 10, integrated pollution prevention and control, the developing and setting of best techniques, otherwise known as BAT, Provisional UK Common Framework. We also considered this Common Framework on the 20th of March last year and agreed to return to the matter. So I refer you to page 676 of the pack to correspondence from the Department dated the 18th of February, seeking confirmation if the Committee is content and that its scrutiny is now complete, or if any further clarification is required. The briefing paper, which we considered previously at our meeting on the 20th of March last year, when we were briefed by Faisal, starts at page 678 of your packs. A copy of the Provisional Framework Outline Agreement and Concordat starts at 681. The copy of Hansard for the 20th of March last year starts at page 731. And to recap, larger industrial installations undertaking specific types of activity are required to use best available techniques, or BAT, to reduce emissions to air, water and land via the best economically and technically viable available techniques. While industrial emissions are a devolved policy area, it is recognised that a common approach in the UK will provide consistency, and the aim of the framework is to develop UK-wide arrangements to support the effective regulation of industrial emissions. The Standards Council will review and, if required, amend the framework periodically every 3 years or on an exceptional basis in the instance of a significant issue. The framework is already operating on a provisional basis pending completion of scrutiny and finalisation, and the Department states does not have any concerns with respect to operations to date. So if members are content, we can complete the scrutiny now. As we know, these common frameworks will be reviewed once finalised. Are members content? Okay, members, thank you very much for that. Okay, agenda item 11 is correspondence. There's correspondence memo for reference, page 738 of the pack. I'm going to highlight just a few items. If there's anything else you want me to come back to, please let me know. So the first one is that I'm going to bring your attention to is 11.6. So refer to page 1065 of the pack, the correspondence dated the 18th of February, sent on behalf of Belfast Works Connect regarding the local growth fund sustaining place-based support. So Belfast Works Connect is a consortium of 5 partners delivering support to economically inactive individuals across 7 of Northern Ireland's 11 council districts. It contains a briefing outlining options to sustain place-based economic inactivity support during the local growth fund transitional year, due to begin on the 1st of April. And I've offered to brief the committee on the proposals. And obviously there's been a lot of talk in regard to plenary and the chamber in regard to the local growth fund and pressures on that. So if you have any comments you're content to note, just want to bring that to your attention, members. I think it's important, it's very live. Okay, members, on page 1072 of the pack, the correspondence dated the 18th of February from the Chair of Bonds Glen Environmental Group regarding the destruction of sperrins, area of outstanding natural beauty and special area of conservation. Members will recall that the issue was raised in AOB at our meeting on the 12th of February. The correspondence highlights concerns at the damage caused due to the extraction of gravel and soil, removal of hedgerows and trees and the destruction of habitats. So members, have any comments you can tend to note, and it's in your papers there for further reading. Yep.
Chair, first of all, maybe I should declare an interest in this because I've been working with Scrib on this, but look, the Minister was written to and come back and said that NIEA had there was no concerns or whatever. But I think when you look at it and you see the amount of material that was removed, is an environmental disaster in this area of the sperrins. And the environmental health on the Derry City Savannah District Council has enforcement on this, or their enforcement sitting on to the minute. I think we really need to be going back to the Minister or NIEA or some of these bodies, even with this correspondence that has come in from the group, and just ask them for further clarity on it. Because you can see it in the photographs there anyway, the damage, but whenever you're on site and you see it, it's colossal damage that's caused here.
Okay. Yeah, no problem. I'm happy to do that. So could we write to the department in regard to just further discussion within the committee group in regard to the correspondence, and an update in regard to department and NIEA. and probably in terms of what they're doing with the council too, and the communications between them and the council then, environmental health in that regard, Tom?
The environmental health, they did make, they did put in concerns to the council about this. On the environmental health have been out on, planning has been out on, and they have enforcement on it at the moment.
And enforcement on it, okay. Thank you. Okay, thank you. Okay, next item I'm going to refer to as 11.9 members. It's on page 1081 of the pact, a correspondence dated the 20th of February from an individual regarding a complaint about a delay of a Northern Ireland Environmental Agency review relating to asbestos disposal oversight at Lisbon landfill. Just making you aware of that. Have you any comments in regard to that, members? No. Okay. And the last one I'm going to refer to is 11.10. So on page 30 of table papers, to correspondence dated the 20th of February from the department regarding an update on the progress of sustainable utilisation of livestock slurry, Sols Phase 2. The department confirms that the third and final £4 million Sols Phase 2 contract has been signed with Natural Wood Products to commence work at High Solids AD plant to be built at their Glenside Road site near Belfast. Have you any comments you can tend to note? Okay, members. Agenda item 12 is the forward work programme. So it's page 37 of table papers. So now turning to any other business. And Michelle, you have an item?
Yes, please. I just want to raise the issue of littering and fly tipping on our rural roads and also on private farmland. I mean, we'll all see it, but we all represent rural constituencies, and it's actually quite disgraceful whenever you drive along the roads now to see what's been tipped out of cars and so on. I'm aware that there's probably a better enforcement regime and certainly recording mechanism probably in the rest of the United Kingdom compared to here. I appreciate that DERA probably has more of a governance and policy perspective on this, and its councils would have the operational side, but I do think that it would be useful for us maybe to make contact with the Minister just with regard to this, because there are issues around animal welfare, there's cost to farmers, there's hazard waste and so on too, which will obviously have an impact on the environment. So all of those things I think make it the remit really of this committee as well to have some sort of oversight on that. But I do think it'd probably be useful to make contact with the UFU to see if they would be could be involved in a campaign, but also to write to our councils, because again, conscious of the discussions that we've had with regards to dilapidation bill, there are likely to be differences in approach to what we do and how the councils approach sort of picking up litter on rural roads and also enforcement around the fly tipping.
Yeah, I agree. I'm particularly interested in this one at the moment. An ongoing issue in Lisbon in regard to fly tipping and the response, and so part of it is the response and the restitution, but then there are issues around cost, but also the preventative piece. What are we doing? Because the other piece we're looking at is the waste management, and we've raised the issue of the change in culture in regard to that, and some of the queries that have been raised is, is it an unintended consequence of future changes in waste management that could exacerbate fly tipping?
I think that's possible, but I think that there's probably a naivety too. People think that if they just throw out a can, they've thrown out a can, it's not going to have an impact. But it could have an impact on an animal in a field, and it could cause untold damage. So there's lots of things I think in and around this, but I think there's an onus on us as a committee, given the fact that we're looking out for our rural communities, I think, to raise this. Yeah,
there are a couple of groups that do some good community work, Keep Northern Ireland Beautiful, and there's another one. Might want at some stage, in terms of the waste management piece, possibly rather, so it's not it doesn't have to be a distinct piece of work, but I think that these people that are vested in it.
We'll all know people who go out for walks and carry bags with them, but the amount of rubbish that there is now along the roads is quite ridiculous. And I just think it would be useful if we could maybe get some sort of an idea as to what's being done. And I do think an awareness programme, which obviously would have an educational piece to it, would be helpful, along with the issues around enforcement. Okay, so
will we...
do you want to... in writing to councils, every individual council, you'd like to hear what they're doing, so we have an overall view.
Because I think all councils will have a different approach to litter on the roads and also the issue around fly tipping.
Yeah, no problem. And then maybe perhaps a letter to the UFU to see what their awareness is of the issue, or farmers contacting them, that sort of thing. Yeah. Okay.
Yeah. Okay.
Right. Yeah, in the first instance, anyway.
Anything else on that one, members? No. Okay. Okay, thank you. We'll do that. Thank you, Michelle, for that. Okay, agenda item 14 then is the date, time and place of the next meeting. The next ERA committee meeting will be on Thursday, the 5th of March at 10 a.m. in room 21. The Minister and the Permanent Secretary will be briefing us at that meeting. So thank you very much, and we will see you next week. Thank you.